But I'll start by asking Colin Lachance to give a bit of an update on a concept that he's working on called vLex. And I'll take it away, Colin.
Thank you, Michael, and thank you, everyone, for the opportunity to come and speak with you. I've got 4 things that I'm going to run through during this period and no slides. The first is who I am. The second is what's vLex. The third is what are we doing with the CCLA. And the fourth is where I hope to spend most of my time, and that is shifting power balance between customers and legal information and tools providers. So I've met many of you before in past lives, my past lives, maybe not yours. I was the CEO of Canley from 2011 to 2015. In that capacity, I had an opportunity to speak at a May plenary of the former CADELPA in London, Ontario. In the time since I left Canley, I've worked with Rangefinder, legal information provider, legal tool provider. I've been an advisor to other legal app developers, and I operated as a consultancy on legal market changes. I called that PGYA. It stands for Please Govern Yourself Accordingly. The legal market is changing, please govern yourself accordingly. So that's who I am. Throughout all of those experiences, I had an opportunity to understand the nature of the legal information market, the tools, the technologies, and very importantly, the customer side of things. I've been very involved in different capacities supporting the Canadian Association of Law Libraries. Attended 5 of the past 6 conferences as speaker, as presenter, just sometimes as attendee. I've done presentations with other law library groups, and I spend a lot of time. It's a significant part of the community that I associate with, or the law librarians, more so than the lawyers. I am a lawyer, but I do very, very little law. In that work, I began to understand where the pain points were, what the opportunities were to do something a little bit different. And so a year ago, when the former Maritime Law Book, if folks are familiar with that, more so outside of Ontario, but there's plenty of people in Ontario who remember Maritime Law Book, they announced they were shutting down. I saw an opportunity to actually put into practice some of what people said they were looking for, choice, and different ways of doing things. So we acquired with some partners the assets of Maritime Law Book, which consisted of a detailed Canadian case law collection from all provinces outside of Quebec, half of which was thoroughly indexed with 150 different legal topics and 48,000 subtopics. About 6 months into our effort, our original technology partner decided to step back and not continue. Fortunately, we had been in negotiations with an international legal information provider called vLex, who had been operating in Spain since 1999, had been very active, and has been very active rather, in Latin America. And they were beginning to poke their noses around North America. They licensed US content, and we were in discussions with them to put our Canadian case law content into their international platform and bring their international content to Canada. So with changes in our initial partner requiring us to rethink how we were going to do it, we got together with vLex. So hence confusion around some of the names, for those who have been following us closely. We now find ourselves carrying 3 names. We were formerly Maritime Law Book. We operate a business called Compass, and that was our original platform. But in the coming months, you'll begin to only hear the name vLex. vLex has some relationship with Canada historically. McGill, Laval, and University of Ottawa had all subscribed to the vLex global platform. vLex Canada was something new, and now vLex US is something new. But in the short period of time that we've been in operation under that name, we've started to make some headway. Last week, the Law Society of Manitoba, for example, turned up full access to vLex Canada and vLex US for every lawyer in that province through their Law Society portal. We were excited about that, not only to get that toehold in the marketplace, but we actually displaced one of the incumbent providers of US legal information in order to get that business. But what I'm here to talk to you about today, now I'm at point 3, is what we did with the CCLA and where we think it creates opportunities for publishers, law associations, and courthouse libraries across the country. I've had the good fortune of knowing Rick and Jennifer and others at the CCLA for a number of years. I've been a member there as well. They've indulged my interest in different projects over the years, and while I was at Canley, I had opportunity to assist in sharing information with them through their members. So when there was an opportunity to say, well, what can we do differently with Courthouse Library, CCLA was the logical place to start. So I brought the concept to Rick and Jennifer to say, here's what we'd like to do. You have 1,800 members and a broader distribution list. To us as a new player, that's attractive. To approach you in a traditional way and say, we would like to charge you X based on your 1,800 members is a non-starter for both sides. You, obviously, because you can't value our service at this point, it's premature for you to make that judgment. Also, frankly, it would be really expensive. Us, because at that point, it would have been a risk of overpromising and underdelivering. So instead, what we've done is this. We've provided our service locally in the library on the terminals in the CCLA. When a user comes up, they see the library toolkit. There's a Lexis button, a Westlaw button, a Canley button, and a vLex button. They click that button. Then they're presented two screens, or sorry, rather two buttons. One button says proceed anonymously. So the premium service that is available through the library, a user can go on and carry out the research without us tracking anything. Everything is fine and good. The user has in-library access, so nothing particularly exciting or unique here. The anonymous thing allows users like the odd judge who might walk into the room the confidence in knowing that their information isn't going to be tracked. But the interesting thing is what we did with the second button, and that is create a free account to vLex Canada Open. So our Canada service actually has a premium and a free tier. The premium is offered in the library. The free is available to everybody, anywhere, anytime. But when a user selects the free tier from within the library, they are given premium access, not only for the time of their session in the library, but for the next 24 hours thereafter. So if they're in the court to check one thing quickly, they log in, use us, they walk out. For the next 24 hours, they have full access to all the premium services. And premium, in our case, includes things like law journals, a selection of a dozen Irwin Law textbooks, and an increasing amount of secondary source material. If that user comes back a day later, a week later, logs in again, they get another 24 hours. The objective here is to not put it on the association to figure out if there's demand for our service. The objective is to put it on the individual user to determine if they value the service. Because if a lawyer comes back into your library a second time, a third time, or more over the course of a month, frankly, they should just pay the $59 directly and subscribe, and they'll reach that conclusion on their own. If in time our service is deemed desirable by the marketplace, we'll build up that demand. And maybe at that point, at the appropriate time, there'll be a groundswell of interest from your members to say, maybe let's do something a little bit bigger. The point is, the library investment should only be at the minimal, because suppliers like us, and frankly all suppliers, know that you're not going to have your 1,800 members, or in the case of Lexington Addington, your 32 members, half of which are retired. Where is that? Coming through. So it doesn't make sense to price on that basis. The risk should rest with the vendor. This takes me into part 4. What you've probably noticed as you're dealing with a range of new tools, new options, and new services from different providers is that they're not quite sure how to approach you. Or if they do approach you, they're not quite sure how to price. And it's a risk on both sides. So whether we're talking about things like Loom Analytics, which many of you have probably heard about, or Codify, which I'll talk a bit more about in a second, there are a lot of new and very interesting things that you as a library provider offer something far more valuable than one big check and the hope of further distribution, and that is legitimacy. When a new provider, whether it's us or somebody else, comes to you and says, can I get on your desktop? The legitimacy of having that logo appear next to the Westlaw and the Lexis is quite significant and quite valuable. You have the ability now, I think, to take advantage of a lot of these newer services, make them available to your users in ways, whether it's similar to how we've set it up with the CCLA or how others have approached it. Rangefinder, for example, prices for law associations on the basis of a formula that ratchets down dramatically from your membership size. Others will approach it differently. Codify, for example, Codify's business, they began creating an app that allowed people to research changes in regulation and legislation, up to the minute stuff. And then they recently switched in the past 6 months their business model to offer push reporting of these changes. But a group like Codify can say, well, if we're going to make our money off pushing reporting to people according to their specific needs, the library is a fantastic place for us to bring in exposure to the broader scope of our tool set. And ultimately what I hope, and this was my original pitch to Rick and Jennifer, is that it's not just the small guys who can do this deal with you. The big guys are beginning to recognize that the clients have more and more power. Technology costs of setting up things like single sign-on or other ways of accessing this information is going way, way down. The opportunity to create customized services, again, it's going way, way down. Like I said, we can track, put a little tag on a user's account to let them know for 24 hours they have a premium service. These kinds of functionalities are easy to implement. We do it all the time when we log into a website using our Twitter or our Facebook account as the form of login. There's so much more that can be done. And law associations and large clients are increasingly, I'm seeing it in the US, I'm seeing it a bit more in Canada with some of the large clients, are pushing back on the vendors, small and large, to say, here's what I really need, here's what I really want, here's what I can justify spending money on. I think collectively you have an opportunity to make a significant shift. The last thing I'll point on is a bit of a downer, but I want to focus on the silver lining. Many of you who've been in the association worlds for the past few years are likely familiar with the investment that the Law Foundation had previously made to support Library Co. access to LexisNexis. That is a typical scenario where buying big for a lot of people ultimately winds up in one payer subsidizing a small number of users. Our eyes are all open. There's a chance to change it. And so I thank Mike and others for the opportunity to come here and make that story known. Like I say, I've got my thing, but I would really encourage you to take that opportunity to look, beginning with those new apps and ultimately moving to everything else. You can get more services on your desktop for your patrons for less than you're paying right now, because frankly, we're all going to respond favorably to that opportunity to be associated with you. Thank you.